appeal of Tyne passenger transport executive against trading as Nexus against National Union of Rail Maritime Transport Workers and United Unions.
Mr. Reid.
Thank you, my Lord. My Lords and my Lady, I appear on behalf of Mr Bryan of the appellant in this matter, Tyne Passenger Transport Executive, who trade under the name Nexus, and I think in all the documentation the parties have used that shortened form. My learned friends, Mr Oliver Seagull, King's Counsel, and with him Miss Madeline Stanley, appear on behalf of National Union of Maritime Workers, RMT, and Unite the Union, who again collectively have been referred to as the unions in relation to this litigation. As you'll appreciate, this is my appeal against the judgment of the Court of Appeal in this matter, that judgment being the 27th of October 2022, that itself being an appeal by the unions against a judgment
Forgive me, Mr. Reid. Bear with us a moment. We have a slight technical hitch, I think.
I'll carry on anyway, and I'm sure I'll manage. Yes, they brought me Hamlet's laptop. They brought Hamlet's laptop. I'll manage without it, it's fine.
We'll carry on.
We're all right.
Sorry, I'm without a laptop at the moment, but if it comes relevant, I'll take the reference and look at it later.
I'll press on, obviously, if
a laptop will arrive. I just got the wrong, given the wrong one.
Right.
There's an equivalent conversation taking place in another court.
Yes.
Well, I could always go and argue the appeal there. I confuse them slightly. By way of introduction, that itself being an appeal against the judgment of Mr Stuart Isaacs, KC, sitting as a Deputy High Court Judge below. That in the context of proceedings which Nexus had brought seeking rectification of a collective agreement, or rather rectification of a letter of agreement which recorded terms of a collective agreement between the parties. Nexus's case being that that didn't reflect the common intention of the parties, or that there was a unilateral basis for rectification on the basis that one party appreciated that the other's common intention was not being reflected in the document itself. Now, that application to strike out failed in relation to matters. It also included applications in relation to res judicata and issue estoppel. Before the Court of Appeal, the Court of Appeal found that that is the principal focus in relation to this appeal, and the main question on the appeal, that it wasn't open to the Court to consider the equitable remedy of rectification in the context of a collective agreement, which by statute is conclusively presumed to be unenforceable. And the central ground of our appeal is that the Court of Appeal erred in principle in limiting the doctrine of rectification in that manner. Now, I acknowledge that having so determined the appeal below, the judgment of the Court of Appeal led to an order dismissing my action, and technically, therefore, it's a point my learned friend observes upon, that the other grounds of my appeal rest upon obiter parts of that judgment, although you'll appreciate, and we set out in our written case, why we say we sought to appeal and obtain permission in relation to grounds 3, 4 and 5 in respect of the judgment of the Court of Appeal, because they have implications either if I succeed on ground 1 and the action proceeds by way of rectification in the High Court, or, for example, if, in the light of the Court of Appeal's judgment, if held by this court, I contemplate proceedings in the High Court, new proceedings in the High Court involving employees of Nexus, or I seek to pursue issues in the Employment Tribunal in relation to the claims there. So the issues which are addressed in grounds 3, 4 and 5 are not points of redundant interest from our perspective, and you'll appreciate that ground 3 of the appeal addresses a specific question of the jurisdiction of an employment tribunal to deal with an issue of rectification. And that was an important point out of the Court of Appeal judgment, which perhaps changed people's perception, long settled perception of what a tribunal might be capable of doing in relation to disputes before it about contracts.
If you were to succeed on ground 1, I can see that grounds 3, 4 and 5 might be relevant in different ways to different aspects of the case. I can see that you might need grounds 3, 4 and 5 in relation to what's been decided in relation to the Anderson.
Yes.
Perhaps different considerations might apply to other categories of employees.
Well, so far as the Court of Appeal's decision is concerned, they clearly determined questions in relation to issue estoppel and cause of action estoppel in relation to the Anderson claimants in respect of their existing judgment, which reflected historic claims up to the point of those particular claims. I appreciate that those dicta may be relied upon in raising arguments against me in respect of other claimants and the Anderson claimants in relation to claims after later claims under their contracts after the date of those proceedings. But actually the Court of Appeal's dicta are quite limited to the particular grouping of the Anderson claimants' historic claims at the date of the tribunal judgment. It's worth noting that my learned friends on behalf of the union, although they now say, well, this is all obiter and really you shouldn't be troubled with it, sought to cross-appeal to this court to seek, in effect, overturn the Court of Appeal's limited approach and seek to argue that either there was a wider estoppel or a wider position of abuse that extended to the entire range of claimants, potential claimants, even beyond the Anderson claimants, and permission wasn't granted. So as it stands, the continuation of the litigation will leave issues open for res judicata and issue estoppel being argued, regardless of the Court of Appeal, for all of the Anderson claimants for claims after the date of the original tribunal and all other claimants that have never brought proceedings before, whatever format those issues are in. I think that's a long answer to a short question. I'll try and avoid.
Were the Anderson claimants treated by both sides as test claimants for other existing employees who didn't bring claims? Or were they? There
was no formal, I wasn't involved in the litigation at that time. So far as I can see, the position was simply that their claims were brought as unlawful deduction from wages claims. They were all members of the RMT, although I'm not sure that every single member of the RMT who was employed by a Nexus was part of the claimants in that group. But there was no formal of the order of the employment tribunal, as you'll appreciate, can be made, that those claimants were lead claimants so that other claimants' cases would be determined in accordance with the decisions in those cases. So it's open. And I appreciate the point said against me, while tribunals will have cognizance of other decisions, it's actually open for a different tribunal to reach a different conclusion on the basis of issues arising out of estoppel. I acknowledge that a different tribunal wouldn't reach a different conclusion on the construction of the existing letter of agreement because it's bound by the Court of Appeal's judgment on the meaning of that document unless rectified.
Yeah.
So, as I understand it, you are not seeking to reopen the historic matters in relation to the Anderson claimants?
Well, that's probably puts a little high. So far as the Anderson claimants have never had a remedy, they had a determination that there was a failure to pay under their contracts in relation to they had a determination that there was some payable under their contracts on the construction of the letter agreement as upheld by the Court of Appeal. Because of the appeals against that judgment, there's never been a remedy judgment. And
Are you saying you can pull the rug away now at the remedy stage?
I'm not saying it's an attractive argument, but I am.
All right.
I'm never going to shy away from the fact that it doesn't look very attractive, but our position is, and really that's at the heart of, I suspect, the Court of Appeal's view on abuse, that so far as the Anderson claims are concerned, I say that if there is rectification, we say in relation to the High Court proceedings, because the doctrine of rectification would go back in time to change the letter agreement to truly reflect the agreement, I can, in the remedy hearing, say, well, that was a construction which we don't dispute on that document, but rectified, you're not entitled to the sums by way of remedy.
But you have to get over the abuse argument at that point.
I have to get over the abuse argument.
Because there could be a carve-out for those.
I entirely accept that as it stands, the Court of Appeal, and I think it's right to acknowledge that all three judges reached the abuse argument in the sense of abusive me to raise that argument. Absent that, that will be prayed against me to say it's a carve-out. You can't take away the financial gains of their present position, albeit that you can address the issues for their subsequent claims or other claimants.
Well, you might be able to, but you're saying we shouldn't be dealing with that in this hearing.
Yes, yes. Obviously, I say that part of my ground of appeal in relation to that is that the Court of Appeal didn't undertake the broad merits-based judgment for abuse and really ought to have left that to be determined by the Employment Tribunal or the High Court in relation to that issue. And I'll face that argument. I may face that argument, I anticipate, in relation to other claimants, but it's an argument which needs to be addressed separately and dealt with. Never good to start on an unattractive bit on your argument, and I'm not going to shy away from the fact that it is an unattractive bit of my argument. I don't want to deflect from the fact that, however that may seem unattractive, it doesn't detract from the primary proposal from the point of view of Nexus, that they're faced with this position. They have a collective agreement which has been incorporated into contracts of employment, and that collective agreement, they say, does not reflect the agreement reached with the unions in that collective bargaining process and is susceptible to rectification. Of course, that has significant importance going forward, because as it stands, even today, the union's position will be that it governs the terms and conditions and entitlements of the individual workers. And of course, there is, and the lawyers no doubt are to blame in relation to this, because of the protracted length of this litigation, a significant period between the judgment in the Anderson claimants and now embracing not only them but other claimants. So it's a significant issue beyond even my attempt to use Lord Legate's phrase, pull the rug from underneath the Anderson claimants in relation to their remedies. So just by way of brief introduction, I've already addressed ground 3 and the importance of the rectification point. Ground 4 we've touched upon, which really relates to the abuse of process. It's right to note that Lord Justice Underhill was the only judge below to form the view that there was a cause of action and issue estoppel, but as I acknowledge that all of the Court of Appeal adopted the approach that it would be abusive in relation to the Anderson claimants in my approach. And ground 5 is a unique position in relation to the judgment of Lord Justice Underhill, as he addressed a privity of party issue, which only really arises in the context of the High Court litigation, if the High Court litigation continues as we say it should, with only the unions as a party. But again, that only goes to cause of action estoppel and the Anderson claimants and their existing judgments. Can I turn then to the central question? And what I'm going to endeavour to demonstrate is essentially, from our perspective, one can make a number of propositions some of which we don't think are challenging. The more challenging ones are the latter ones. The 6 propositions which we seek to develop really are that rectification is an equitable, flexible, equitable remedy. I don't imagine any challenge in relation to that. Rectification is not rectification of a mistake in the transaction, but a mistake in the way in which a transaction has been expressed in writing. And that, of course, is important, that whilst there is an evidential focus on the underlying transaction, the actual focus of rectification itself is a document. Thirdly, we're not concerned, and this no doubt will be a point of issue, we're not concerned with the underlying agreement's enforcement. We're not seeking to enforce the terms of the collective agreement. And indeed, we make the point, which I'll take your lordships to, that rectification may apply where the underlying agreement is itself unenforceable. The fourth point we make, and this is really at the heart of the disputes between us, we say there's no reason in principle, this is a general point, why rectification should not extend to the rectification of a document recording agreement, although the agreement may not be enforceable between the parties. There's no principled objection to rectification applying in that way. And as a fifth point, we say that that's particularly the case if, although the document doesn't create rights between the parties, it does have implications for the legal obligations of one of the parties. And of course, that's at the very heart of the nature of this case. The collective agreement, and we don't take issue, of course, with this, it's a statute and we'll come to the statute, that the collective agreement may not be enforceable between Nexus and the unions, but the effect of the collective agreement, because it was intended to impact and be incorporated in the contracts of employment of Nexus's staff in grades 1 to 3, had legal consequences for Nexus. It created obligations for Nexus in relation to pay. And so we say even if an agreement is unenforceable between the parties, that shouldn't stop as a principle the exercise of discretion where the agreement may impact legal obligations for one of the parties. Now, all of the points I've made thus far are really points about the nature and flexibility of rectification as a doctrine. Our final point is to say that there is simply no reason in principle to limit the application of the doctrine to collective agreements, and the legislative framework in respect of collective agreements does not impose a restriction or require a policy restriction which prevents the court from dealing with a rectification application in respect of a document recording the same.
Sorry, could you give me your sixth proposition again?
Yes, my sixth proposition is that there's no, to put it succinctly, is there's no reason to limit rectification from its application to a collective agreement.
There's no policy reason why you shouldn't rectify a collective agreement.
Correct, yes.
Is there a general principle of rectification that it shouldn't be granted where third-party rights are affected, third-party rights have intervened?
A general principle that rectification shouldn't be granted where third-party rights.
If it disturbs the rights of third parties acquired as a result of the original form of the agreement.
Well, I don't think that's the case in terms of and if that were the case, it would only be the case that rectification will be limited to the position going back in time as opposed to the position going forward. Because if you take it in this, well, number one, I don't think there's such a limitation. But number two, even if there was such a limitation, it isn't quite in this context the same type of principle, because obviously when it comes to contractual rights and wages, one's looking at historic entitlements, but future obligations are not built upon any particular expectation or status, and rectification, even if that were the case, must be capable of changing the position going forward. Otherwise, effectively, and this will be a policy issue again, you'd have the effect that to take the example that if the collective agreement, to try and separate out the point of principle, if the collective agreement had expressly said this is legally binding, and there would be no argument of principle about it, it's still intended to incorporate into contracts of employment. The effect of such a position would be that if there'd been a mistake between the parties, you'd never be able to correct a position absent of further collective agreement between the two, which would appear to defeat the justice of the situation to correct where matters stood.
See, then it might operate prospectively, but as a general rule, as I understand it, rectification is retroactive.
Is one, sorry?
As a general principle, rectification is retroactive.
That is correct. I think we point to that, and it's true that if it weren't retroactive, I wouldn't have an argument in relation to the remedies issue in respect of the Anderson claimants on their existing judgment, because it is retrospective. It goes back in time.
But as I understood, let's just assume that there is some sort of prejudice to third parties, bar to rectification.
Yes.
As I understood it, your answer to that was, well, it could only apply prospectively and not retrospectively. So let's assume that's right. But you were then accepting, are you not, that as far as the Anderson claimants are concerned, in the past, that's the end of the story, even if you in principle might in other circumstances be able to rectify a collective bargain. Here, there is the bar that prevents the third parties being prejudiced, and therefore you fail before we get to any question of prejudice, any question of abuse of process as regards the Anderson claimants for the past claimed.
Well,
as I understood your answer, but I may have misunderstood your answer.
Well, if that was my answer, I apologise, because my answer was that was in principle to say that the rectification operated retrospectively, so that my primary position was that there was no bar from the point of view of the impact upon by reason of its impact upon third parties.
But we know that there are bars to rectification that include, for example, if property is transferred to a third party and the third party is a bona fide purchase for value, then you can't rectify.
Yes.
And that is seen, I think, in the books, potentially, as an example of you can't rectify if there's going to be prejudice to third parties.
Yes, I acknowledge that there are cases that support the proposition that if a contract has been performed in the sense of the sale, as you identified, by a third party acquiring, that rectification that can't be heard to change their rights. I say here that it's a rather different proposition in terms of the incorporation of terms in relation to a contract negotiated by the union to have effect in what is the contract between the employees. That parking for one moment the entitlements that the Anderson claimants might say they have to the judgment that they've obtained for historic claims, which I acknowledge has a particular subset issue around it. We say that this dispute is a live continuing dispute that hasn't determined or resolved the position of third-party rights in terms of the employees, because it's a live dispute as to what their terms and conditions are.
Just in terms of the nature of rectification, if one thinks of it as a remedy, I mean, it's a flexible, equitable doctrine, as you say. even if presumptively it operates retrospectively, one would think that if the equities have affected the due operation of the doctrine, that there would be scope for a court to say the doctrine applies prospectively, but not in relation to retrospective events which have been determined according to the text of the document as it applied in the past.
Well, I acknowledge that the flexibility of the doctrine means that it's open to a court to exercise the discretion as to how the exercise of that doctrine will happen. We'll come to some of the cases learned by my learned friend which reflect the court's pragmatic approach in relation to that. I don't think I could argue in principle with the fact that it would be open to a court to hear an argument on rectification to say you should exercise your discretion, but in respect of the principle of it going back in time, limit the effect of the rectification in a particular way.
Because, I mean, just thinking about the Anderson claimants, I mean, they didn't know that there was going to be rectification of the terms of the Red Book. They thought that they were contracting in their individual employment contracts on the terms as they appeared in the text of the Red Book at that time. And they will have made decisions as to whether to accept employment with Nexus or to tender notice of resignation because they don't like the terms on the basis of the terms that they could see in the Red Book, which had been dropped down into their individual contracts of employment.
Well, of course, one has to recognise...
And I think just to pursue the point, I mean, if they have adjusted their positions in the light of what they understood their contractual rights to be, taking it from the text of the Red Book as it stands, would that not be a basis for saying that there ought not to be rectification, or at any rate rectification of the Red Book in such a way as would affect their rights as under their individual contracts of employment?
Well, I think there are two answers to that. The first is that that might require specific evidence in relation to individuals as to whether or not they had made such a decision or view in relation to their affairs based upon their view of the contractual terms. I mean, without...
Sorry, well, just on that, if I may.
Yes, of course.
I mean, isn't it an ordinary principle, not requiring evidence, that people are entitled to rely upon the contractual terms as they appear to be in their own contracts of employment?
Yes. I mean, the second point really goes to the first in this sense, in that, and I appreciate that this was an argument that was unsuccessfully advanced both before the tribunal, the AT, and eventually before the Court of Appeal. Nexus's position, of course, was that what was being contended to be the wording in relation to their contracts of employment was wrong, and that had never been the intention, that it would affect their contracts of employment to give them an entitlement.
If I may ask, whose intention?
Well, it's Nexus's intention. We say a common intention between the parties in the collective agreement. At the heart of the fact...
Well, that's the point, isn't it? Because rectification, as between the parties to the agreement, here the collective agreement, they know what the agreement was meant to say.
Yes.
And therefore they're not prejudiced by it being treated as if it always said that. But when it comes to a third party, they weren't part of that mutual understanding. And so I think my Lord's point is that as far as they're concerned, they're entitled to take the contract as what it says until it's altered.
Face value.
Yes. I suppose why I'm quibbling slightly in relation to that proposition is that if the contract had been, from our perspective, beyond doubt as to its wording, that might be one thing. But our position is that there was no issue raised by the unions or anyone on their behalf for I think it was about 2 years after the collective agreement was implemented, and various factors suggested that the way it was being operated by Nexus, who consistently paid on the basis that there had been no increase intended to overtime rates in relation to the staff or shift allowances.
But that was wrong. We know from the Agarwal case that that was wrong. It's a matter of interpretation of the employees' contracts of employment as incorporating the text of the Red Book as it actually stands prior to rectification. And indeed, that's the foundation of the unlawful deduction of wages claim, isn't it?
Yes, it is, of course, because that has been conclusively determined against me. I suppose my point is that if you're looking at the exercise of the discretion about whether or not rectification went back in time, the question may be more subtle than simply saying, well, the workers understood their contract to say X, they continued to pursue their labour on the basis of X, when in fact the underlying facts show that the parties had operated in a way that suggested that the construction eventually advanced by the unions wasn't the one which applied. And of course, Nexus's consistent position proved to be wrong on construction, and then initiated by way of rectification was that this wasn't an entitlement that the workers had. And so I suppose my issue is to say that it's not quite as straightforward as to say there are third parties who laboured thinking that they had a particular entitlement to payment in relation to overtime.
It doesn't really matter what they thought, though. The law has to go on the basis of what the contract's taken to mean, or if it's rectified, what the parties to it always intended it to say. The point is that the employees are not parties to that collective agreement or to the understanding that as to what it was meant to say. So, well,
of course, that's a central part of our case as to why, if one puts to the moment to one side whether or not rectification should be in some way limited so that it doesn't go retrospectively back or only applies to certain groups and certain positions, but undoubtedly applies going forward to correct the position. I'm not conceding the point, but just taking that for the purposes of argument.
It might be important analytically to distinguish those two.
I acknowledge that. The practical problem is exactly that from our perspective, that what the unions seek to drive is to say that, and we say this is a triumph of form over substance, is that the rectification application ought to be directed at rectification of the contracts of employment, with exactly the problem that one's focusing on parties who simply were not parties to the negotiation. And although it's said that there may be evidence about what the negotiation was and there may be disclosure by the unions, it's sort of missing the point that the fundamental issue must be addressing what the parties to the negotiation believed to be the terms which they had reached.
Right.
Well, you couldn't really, I can't see that their contract needed any rectification, the employee's contract. That said what it was meant to say, which is that whatever the red's in the red book's in our contract. So
well, that's absolutely right. Their contract incorporated collectively agreed terms applicable to them. And so in terms of their contract, it needs no rectification.
No.
What's needed is the rectification of a document which it seeks to incorporate.
Right, but can I just check? Do you accept that the unions are not agents of the employees when they engage in negotiating the collective agreement?
I think that is the settled position in relation to the law of collective bargaining. They are not agents.
Right.
So certainly couldn't be agents for people who weren't members of their union, right. And it's doubtful whether they're agents of even their own members, I think.
Yeah, I mean, I think the existing case law and the often dispute here is that they are not. So, I mean, just pursuing that, if I may. So the position is that you get parties who, in legal theory, are completely distinct from the employees. The employees have their own contract with Nexus. The union, not being their agents, have negotiated a collective agreement with Nexus. And it's just that it's a term of the the contracts of employment, that certain aspects of that collective agreement are incorporated into the contracts of employment.
Yes. So, and that's a necessary requirement, that there has to be a contractual bridge.
Yes,
but the bridge is in the contract of employment, not in the collective agreement.
Yes.
Then there's an express term, is that right in this case?
I haven't got the terms, but there is, whether by custom or practice, I think there's an express term in the wording.
That's
may
what
have
the
the
statement of
conditions
facts
service in the
implies,
bundle.
but I haven't seen it.
But I mean, it might be said that that express term is to incorporate a particular text as it stands at a particular time, i.e. the Red Book text that the employees are aware of, because in their contract of employment they're being told, for this part of your contract terms, look at the Red Book and you'll know what your contract terms are. Now that is to look at the, it might be said, is to look at the Red Book as it stands at the time that they take their contracts of employment or remain in employment. I mean, I follow the point that if there's rectification of the Red Book going forward, then they're on notice of that changed position, and it ought to be that which is incorporated. But wouldn't the natural interpretation of that term for incorporation of the Red Book be to say it's incorporating a text?
It's incorporating a text, but it's a dynamic text on any view, because obviously the Red Book is a reflection of collective bargaining. That's the point of the issue. And that collective bargaining changes, as indeed there was an intention to change. No issue about that here.
But only prospectively.
Yeah, it's only prospectively, surely. That's the dynamism is, well, there might be another change to the collective agreement tomorrow, and then that gets incorporated. That seems a very different kettle of fish, if I may say so, to saying, well, you think you know what your contract rights are, but do you know what? There's going to be litigation between distinct parties, between someone who isn't your agent, the unions, and your employer, and somehow that's going to affect what you thought your contract terms were at the time that you were in employment, deciding to remain in employment, not seek another job, and so on.
Yes. Well, so I suppose it's consistent with my approach to rectification, that subject to the points you raise about the equities in relation to it, that the fact that it's incorporated a set of documents, those documents being capable of rectification and that rectification going back in time, the fact that the bridge incorporates those documents does not fix those documents as standing immutably if rectification properly lies to change them.
But it may have to give to accrued third-party rights which are prejudiced.
Well, that's being put to me.
Yes.
In principle, I'm not accepting it, but I acknowledge the argument that one approach might be that, and there are subtleties of this issue, because obviously there's the Anderson claim, it's the historic position, there's the position from the point at which we articulated the rectification claim itself.
Oh, there's a whole range of possibilities.
And a whole range of possibilities between my...
between one extreme, your extreme, and the other.
Yes.
And I mean, if I may say so, it's not just the Anderson claimants who have, or may have, thought that they had contractual rights and that they were being underpaid in the past. Other employees in that period may have thought, well, the meaning of my contract of employment is look at the Red Book, it's those terms that apply to me, and could, in theory, even if they weren't one of the Anderson claimants, now bring claims in relation to the past period, saying, well, those were just my contractual rights and you've underpaid me by reference to what my rights were.
There'd be time limits on how far you could go back.
Yeah, subject to time limits, of course.
I mean, it's right to say, we can go to the details. The bundle, they're in the bundle. There are subsequent claims to the Anderson claimants by other parties, including Unite claimants, and spanning other periods of time. And those claims have all been stayed quite recently, and this isn't in the bundle, because some of the claimants were out of time in the Employment Tribunal in relation to some of their claims. There have also been some proceedings in the High Court, as I understand it, brought by some of the claimants to overcome the limitation issues in the Employment Tribunal. So there are other claims, I'm not questioning that.
Yeah,
although
the reason for me making the point, just so we're clear, is to try to bring out that there are some underlying issues of principle, both in relation to construction of the employment contracts themselves, and what does the incorporation by reference actually achieve. Questions of principle relating to the flexibility of the doctrine of rectification, if third-party rights have intervened, which arise separately from the question of, and there has actually been litigation involving the Anderson claimants, which may involve questions of abuse of process or cause of action estoppel. There's a sort of series of questions that potentially arise.
Yes, I suppose, and I don't question the fact that those issues are properly raised as being there. Obviously, so far as this appeal is concerned, and the approach that the Court of Appeal took, is I don't get to first base, to use a colloquialism, which is that I don't even get to the proposition that we can have, whether I concede the argument that it's prospective and that the past is the past and those who've entitled to assert their position can maintain their position, which I don't accept, but if that is the right equity in terms of the rectification, the Court of Appeal's approach was effectively say it's an absolute bar to the court looking at the collective
hurdle.
An insuperable hurdle, exactly right. Although the irony, and it's a point I'll come back to, is that despite that proposition, the union's case is actually you can look at it all because they just say, well, you've got to bring it as a rectification application with the employees looking to rectify a contract which doesn't need rectification, and we'll still have all the evidence about whether or not the collective bargaining had been reached or the principle had been established in that proposition. It's just that in some way we can't possibly have the unions, the parties who were directly involved in the negotiation, being the parties to rectification. And that's, we say, is a fundamental problem of the Court of Appeal judgment.
I mean, in a sense, I think you've made clear that you're relying on rectification both for retrospective effects and prospective.
Yes.
And even if there were problems with the retrospective effects, you say we've got to grapple with the first issue in relation to prospective effects. In other words, what the Red Book actually means, even if it's affecting employees' contracts of employment from tomorrow.
Yes.
And so we have to reach a view as to whether the Court of Appeal were right in the rather, it might be said, absolutist approach that they adopted to the doctrine of rectification.
Yes, and of course, I entirely accept that before this court, more than any other, you're concerned about principles and approaches to be taken, and it may be that in your view that exercise of discretion in terms of rectification has to reflect that. From my position, of course, the arguments about whether or not rectification should be limited or not granted retrospectively or prospectively were never really canvassed, because the application that was made to strike me out was to say you can't have rectification for collective agreement at all. Yeah. And so
you're entitled to say that none of these arguments have been made against you. We're raising them with you now, but
let me be clear. I'm not questioning the fact that you're entitled to debate them with me now, and I have to deal with them. I'm only observing that actually, so far as the principle is concerned, they may be arguments which properly are resolved at a later stage and dealt with by way of argument. And I don't mean it impertinently. The reason I sort of slightly quibbled about the individual facts in relation to matters is that obviously Nexus will have its own case to advance as to what was being communicated to the workforce and when about the effect of the terms and what issues are being raised about whether or not it's right that rectification should be limited in a retrospective way. But essentially I'm saying that's a battle for a different day rather than a battle for today. My battle for today is more fundamental.
And on that fundamental question, you said there's no reason in principle why collective agreements shouldn't be capable of rectification. Are you limiting that argument to terms of collective agreements that are to be incorporated into contracts, or are you just saying broadly collective agreements?
Well, I take that in two stages. My primary position is that there is no reason in principle why rectification should not extend to the entirety of a collective agreement if the collective agreement is recorded in a document that didn't reflect the common intention of the parties, or in that case of unilateral rectification. There's nothing in principle wrong with that. I would, however, if there was an issue of principle, cling to a second line, which is the one you've identified, which is that there may be a subset of that if the particular collective agreement was intended to have direct impact in relation to contracts of employment and incorporated in relation to it, so as to affect third parties. And I appreciate that cuts both ways, because it could be said against me, well, that's impacting on third parties, but equally, I say, prospectively, it has a significance going forward.
Well, there's no point in the court granting rectification if it won't affect anybody's legal rights or obligations. But your point is that at least insofar as the terms are incorporated, it does.
Yes.
But I thought Lady Simler's point was, are you not therefore bound to say that it's only in relation to those parts of the collective agreement that can have legal consequences? Because clearly there are some parts of the collective agreement that can't.
Well, let me answer that in two ways. So, when we come to look at some of the cases relied on by my learned friend, I acknowledge, and it's a passage in Chitty in a couple of cases refers to, that when it comes to the exercise of discretion, there's authority to say that the courts won't exercise rectification if there isn't a substantive issue between the parties, if there's no purpose.
Equity doesn't act in vain.
Yes. and so I agree that that is an exercise of discretion. I acknowledge that in collective agreements, there are parts of collective agreements which are not apt or intended to be incorporated in individual contracts of employment. So quite commonly, and when we look at one of the cases that's relied upon by my learned friend, the NUM and National Coal Board case, which involved a collective agreement that included a tribunal for referral of disputes between the parties, well, that's something which wouldn't have been incorporated in the contracts of individual employment. I say as a point of principle, though, there's no reason to say that rectification wouldn't be possible. Then the court may be reluctant to exercise rectification if there are what might be described as being broad points of principle or rather ill-defined terms. But if, let's say, it was something that was as specific as a collective bargaining structure, although it wasn't directly incorporated into contracts of employment, but it was said that the structure didn't accurately reflect the agreement, my principal position is that there wouldn't be a bar to rectification, although I acknowledge that that isn't something which one party could sue the other for breach upon.
I mean, I suppose it might be said in that sort of case that if it's the structure of collective bargaining, there's at least potentially a sort of indirect effect on individual contracts of employment, because they are going to reflect, I'm assuming in your example, whatever the ultimate collective agreement is, and that will be affected by the bargaining structures that are in place.
To take a more disparate example, where I still say the principle is there, but I acknowledge that the principle is, it may be said, well, that doesn't impact directly on the rights of individuals, is a collective agreement may typically provide for facilities for the union in the works premises, an office, or access to notice boards or facilities for union officials. That's a common collective provision. Now, I acknowledge that those would not be enforceable rights by the union. The union, unless it's expressly said to be legally enforceable, can't enforce those particular rights. But my point about rectification is that because I'm not enforcing the underlying agreement, if that document didn't accord with what had been agreed between the parties, it would still be open to rectification.
But it sounds to me that that principle, if you're going so far, you're saying the courts can rectify any agreement, whether it's got anything to do with legal rights at all.
Well,
I mean, the point about, let's just assume we have a collective bargain that is entirely about the structure of the negotiations and so on. Entirely nothing whatever to do at this point with pay or anything that's going to be incorporated. It's just a separate collective agreement. We know that's not binding.
Yes.
But you say you can rectify even that, even though it doesn't affect the legal rights of one of the parties, which I think is one of the other propositions that you're putting forward as making it, I think you said particularly the case.
Yeah,
Yes, in this particular case. Yes.
But you say any agreement in a document can be rectified, whether it's got anything to do with law or not.
I don't think I need to go that far.
Well, I agree with you to go to dinner tomorrow and you say, yes, I'll provide the wine and so on. Can we go to court and get it rectified?
No.
Why not?
Well, in terms of that type of agreement, we wouldn't get it rectified because it's a discretionary remedy and the court wouldn't act in relation to that particular
It would serve no useful purpose.
Yes, it's
So
back to the
you're saying
practicality of the
the court could in principle rectify anything is your position, but it won't do if it wouldn't serve a useful legal purpose.
I mean, the phrase that I draw from, it's a passage my learned friend referred to in Chitty, which I say is properly reflected in the cases, in the bundle. Bear with me a moment and I'll dig up the relevant passage. Yes, it's B1904. My learned friend, this is in Chitty, and my learned friend relied upon the first sentence, rectification will only be ordered so long as there's an issue between the parties as to their legal rights inter se. But in fact, the full passage says, if there's no such issue, or if no substantive relief is sought and no practical purpose will be achieved by rectification may be refused. So the approach I take to answer it is that I say that in principle, the existence of legal rights between the parties isn't a necessary requirement for the purposes of rectification, but when it comes to the exercise of the court's power of rectification, the right analysis is to say that the court has a discretion, it's an equitable remedy, and it typically won't grant relief if there's no substantive relief being sought or no practical purpose is being achieved by the application. So attractive though it might sound, an invitation to dinner serves no practical purpose by way of rectification.
I mean, but in a sense, it would serve a practical purpose because Lord Burrows would know whether his friend was going to pay for his wine or not.
Yes.
Well, he wouldn't, because the friend could just say, I'm not paying anyway. That's the point. It
Yes.
doesn't matter. So the court's wasting its time to...
But they'd say the same about the collective bargain.
Well, there it does affect legal rights, though, doesn't it?
It would. It would affect the structure of the bargaining.
Yes.
You can just walk away from it. So it's no different. I think your answer to me, as I understand it, is that in the context in which we're talking about collective bargains, there will actually, insofar as anybody's going to be bothered about this, be a practical purpose.
Yes.
And therefore, as a proposition, it is possible, even with regard to the what I would call the non-apt for incorporation parts of a collective bargain, it is possible that could be rectified. Highly unlikely in practice because there wouldn't be a practical purpose, but nevertheless, I think that's, as I understood it, what your answer was.
Yes, you correctly summarise it. Here, though, and obviously I'm specifically focused upon this case, don't depart from my general proposition, but on the specific proposition of this case, this was a very specific part of the collective agreement, which the intention of the parties was to affect the contracts of employment of individuals. So although it didn't create rights, the document didn't create rights between the union and the employer. That I acknowledge, because that's the effect of...
It indirectly created
It did
rights
create
for
legal
employees.
rights. Yeah.
It indirectly create rights for the employees in that group,
Yeah.
and directly created an obligation upon my client, because the effect of it was to impose contractual obligations as interpreted upon Nexus.
Yeah, I think that was your fifth proposition.
It is, yes.
In effect.
Yes.
Focus down on the practical effects in this case.
Yes. I haven't troubled, and perhaps for these purposes I needn't trouble, to take you to the two passages in Snell that we refer to, because they essentially articulate. The first is the passage at 1601, that's page 1911 of the bundle. That's the introduction to the chapter in Snell on rectification. And my Lord Legate, we, not in anticipation of composition of the court, included a passage from your judgment.
So sorry, Mr. Reed, what was the page number you gave?
On the Snell, it's 1911.
Thank you.
That's it's the opening paragraphs of the chapter on the remedy of rectification, and little a sets out, we say, an accurate summary of the position in relation to the court's power in respect of rectification, noting that it reflects the terms of a written agreement not according with the true agreement between the parties, and it, as identified in that passage, and I don't think these are propositions of dispute. It's quite clear that there's no need for there to be an enforceable agreement between the parties for there to be an application for rectification. And it's also right, although I acknowledge that it's an area of some contention, that it's possible for there to be rectification where the mistake is a mistake of only one party, where the other party appreciates that that party is executing the document under an assumption as to a common understanding between them, but they appreciate that is wrong.
And you put your case on alternative basis?
We do, yes. Below, in terms of the action, we put it on the common understanding between the parties that it was to achieve certain purposes, but we also put it on the second unilateral basis. The second proposition that we draw out of Snell, and this is back to the width of the documents, is at 1914. That's Snell 1600. That's Snell paragraph 1604, which deals with the types of documents where the courts have granted rectification. In our case, we point to one specific example which may be interesting from the point of view of examples of situations where on paper there's no effective rights being created at that point in time between the parties. And that's a passage in David Hodges' book in his non-judicial capacity, and that's his book, Rectification, the Modern Law of Practice Governing Claims for Rectification and or Mistake. And the passage is at B1909. And that concerns contracts for the sale of land. And I perhaps don't need to read the whole passage. It focuses upon the operation of Section 2 of the Law of Property Miscellaneous Provisions Act 1989, which you'll appreciate was a successor to Section 40 of the Law of Property Act 1925. And on the second page of that book, 1910, we actually, it's in the bundle, but for these purposes, I'll just take you to the passage in the book. He sets out the effect of, sets out the terms of Section 2. And of course, Section 2 provides that if, for example, I had an oral agreement with you to sell my house, we know that that's an unenforceable agreement in terms of specific performance. It creates no enforceable rights. If we exchange contracts in the modern form of conveyancing, and those contracts don't contain identical terms because there has been an error in the documentation, then the effect of Section 2.1 is that one wouldn't have a contract which consists of documents which are exchanged where the parties have expressly agreed the terms in their entirety of each of those documents, because they wouldn't reflect each other. So even though we've got written documents, each signed by the other, it still would be completely unenforceable. And it's quite clear that what's contemplated, that such an error, because there would have been an error in the documentation being provided, wouldn't prevent the courts granting rectification of one of the documents, or perhaps both, to reflect the common intention of the parties that the terms of the contract should be consistent between the two. And one can see that within the section itself, because it specifically deals with section 2, subparagraph 4, what will happen if there is a rectification. And in fact, it provides, contrary to the principle of rectification going back in time, that rectification will only apply in terms of the contracts from the date at which it's specified in the order for rectification taking effect. Now, my proposition really from that is that what one can just see stepping back, that's dealing with a situation where there's an agreement between the parties that creates no rights, completely unenforceable. I acknowledge that the effect of rectification is to bring into effect an agreement that is intended to have legal rights, but it doesn't, the fact that there is no creation of an agreement that creates rights between the parties at the point they entered into the agreement or when they exchange contracts on misaligned terms, doesn't change the fact that the courts would grant rectification in such a situation.
I mean, Section 2.4 is quite interesting because it shows the flexibility of the doctrine of rectification, and one might say reflects the basic idea that people need to know what their contract rights and obligations are at any particular point in time. So that seemed to contemplate that if you had the mismatch in the exchange of contracts, so if a party went to their lawyer and said, well, am I bound at this point in time, they'd say no, because the requirements of Section 2.1 have not been satisfied. But then there's a rectification claim, and the outcome of that is to bring the two contracts into alignment so that they are then binding. At least Section 2.4 contemplates that, in effect, the court says you're only bound from such time as it would be just and equitable for you to be treated as subject to that contractual obligation.
Yes, well, I acknowledge that section contemplates that the court would exercise a power to specify a particular point in time that the rectification would take effect, and that the court might do that even though it didn't direct that rectification took effect from the original date of exchange when one party perfected the document.
Yes, and one can see why, because if they did that, one party might say, well, you're in breach of the terms of the contract, and I now treat the contract as rescinded. It may be very important that you know what your contractual rights are so that you have a fair opportunity to comply with them before the other party can sue you on that contract.
Yes, but without straying back into the earlier argument.
No,
See, that might depend on. I haven't questioned the flexibility of the doctrine. I have questioned whether or not.
Your point is this shows that you can rectify something which isn't, has no contractual or legal effect.
Yes. And I perhaps don't need to take you to it. It's a case that was referred to below, but it's a principle that one can see that it may extend even to documents which are not reflective of a contract or a document between the parties which they both enter, because there's a Persimmonian, Holmes and Hiller case where, acknowledging that it was part of a suite of documents, perhaps I should just call it up, it's 1627 in the bundle.
1627.
1627. Persimmon, Holmes and Hillier. Decision of the Court of Appeal.
It was a sale of shares.
I'm sorry?
It was
Oh, I'm sorry. Yes,
a sale of shares.
It was part of a suite of documents relating to the purchase of development land. But one of the issues in the case was whether or not there should be rectification of a disclosure letter that was written by one party, and an argument was advanced on the appeal that rectification didn't extend to what was effectively a unilateral document created only by one party to the transaction. And the Court of Appeal found that rectification, such a disclosure document, was capable of rectification. The relevant passage in respect of the Court of Appeal's judgment, the leading judgment being given by Lord Justice David Richards, with whom the other judges agreed, is at 1636. Beginning at paragraph 41. Now, I acknowledge that this was part of a suite of documents which were intended to give effect to the contract of sale, but consistent with, we say, the approach that the courts take, subject to practicality of not really identifying limitations or boundaries to when rectification might be exercised, the Court of Appeal saw no issue with the fact that this was a unilateral document created by one party.
Well, you can rectify a will, for example, which is a unilateral document.
Yes. I think that's an example we give in respect of...
in effect, it's an example that Lord Justice David Richards gives, where he refers to Buckland's settlement trust, a settlement. I mean, you can have a settlement in a will. A settlement is a unilateral document declaring a trust. Now,
it may be said against me that all of those are examples of them conferring or creating rights in relation to third parties. Obviously, I'm not going back to my primary proposition that isn't a limitation, but even if it was a limitation, there's no material distinction, we'd say, between the rights or obligations being created either on one party or conferring a benefit on a third party, simply because it doesn't create rights between the parties themselves underlying the agreement. So my purpose in going to this is really to show that what one sees when it comes to rectification is really that the boundaries are defined by practicality and discretion, where equity requires that a party should not hold to written documents or written terms which don't reflect an underlying agreement, but they aren't built upon points of substantive principle. much of my argument here is really directed to a proposition that my learned friends make. It's at paragraphs 15 to 18 of their case. That's page 139 of the bundle. Paragraph. They say their case asserts that there are two well-established principles of law, but both of which I really take issue with. The first is that rectification will only be ordered so long as there's an issue between the parties as to their legal rights inter se, and that's the passage that referred to chitty on contracts that I took you to, where I say actually if you look at the totality of the passage, actually rectification is being recognised to extend not only in relation to situations where there are rights between the parties, but issues also where there may be a substantive issue or practicality in terms of the exercise of that discretion. It's really practicality that drives that particular point. The second proposition, which I'll come on to, is at 17, which we say overstates the effect of the case law and the statute, is that the courts have no jurisdiction to adjudicate between employers and trades unions as to the terms of collective agreements made between them. And I make the observation I did at the beginning, that's a bit of a difficult proposition to stand by when effectively what it's saying is, well, you can adjudicate, but only if you have the claim brought against the employees, but you can't adjudicate if the claim is brought against the union itself, because undoubtedly the union's position is that the court or the tribunal can descend into the evidential question of what was agreed in the collective agreement between the parties. It just says that that should happen in proceedings involving rectification of the contracts of employment rather than directly against the union itself. With that in mind, I'm going to look at the question of whether or not there's something fundamental about collective agreements that supports the proposition that there is some sort of policy that keeps the courts away from any issues in relation to them. Of course, it's central to our argument that what's not open is enforcement of the agreement itself, but we say that's a much more limited concept than the courts having cognizance or dealing with issues relating to the collective agreement.
Instead of the Anderson claimants bringing proceedings in the employment tribunal, could the union have brought a claim for a declaration as to what the collective agreement meant?
Well, there are two answers to that. The first is that what they couldn't have done is bring proceedings in the employment tribunal. That's one of the problems, without straying too far ahead, with Lord Justice Underhill's view about privity of parties, is that unlike typically where one party is privy to another, where they could have brought the proceedings themselves, the unions couldn't have brought a claim in the employment jurisdiction. That's the jurisdiction there.
No, fine, but in the Chancery Division, like this claim, I'm considering a parallel proceeding to this.
Yes. So my position to that is yes. Slightly quixotically, the union's position has to be no, it couldn't, because even if they had agreed, suppose the reverse position had happened, that they thought that they'd agreed a 5% general pay increase, and that's what was agreed, and the documentation didn't record that, and workers were saying, well, where's my 5% pay increase, and they had failed to achieve it, they couldn't, on the union's case, bring a proceedings in the High Court seeking a declaration that the collective agreement didn't reflect what was agreed between the parties. And we say that that sort of reveals the absurdity of the position, that although it suits them, and I don't say that disrespectfully, it suits them in this litigation to take a particular stance on rectification, actually when one steps back and looks at the wider position, the absurdity of them limiting themselves in those circumstances is reflected. I should note that, of course, and this is a side point that is worth recognising, that from the point of view of the union, of course, I acknowledge that if they had that circumstance, one route would be rectification, and we say that will be perfectly open to them and would be important, subject to questions of discretion and entitlement, because it would establish, if they were right, an entitlement to wages from the point the agreement was reached as to the past. Of course, the union would have its general collective powers to say, well, you didn't agree that, we're going to exercise our rights about industrial action, etc. But that doesn't really diminish in any way the central point that they could seek rectification. It's worth acknowledging here that, of course, the employer's position when it comes to collective agreements, and really this is something which is important to the collective issue going forward, is that the employer isn't in such an easy position when it comes to collective bargaining arrangements because of the operation of Section 145B of Trades Union and Labour Relations Act, the section that prohibits employers from inducing employees to depart from collective bargaining.
The Coastal.
The Coastal. So the employer, faced with a collective agreement that it wants to change, has to bargain to the point where it exhausts all options of bargaining, and only if it fails to do that is it in a position to say, well, I'm going to terminate or offer new contracts or terms regardless of collective bargaining. So the employer's position is rather more difficult than the unions, and one can see immediately what the important attraction is for them, the point of view of the employer, about rectifying a collective agreement where it believes that the recorded document doesn't reflect what the parties had actually agreed. So, can I take you just to some of the case law and collective agreements? The legislation itself, we find in the bundle, is at 842.
Sorry, 842.
842. I'll briefly touch on, and my learned friends in their answer helpfully set out some of the history in relation to this. 179, subparagraph 1, collective agreement shall conclusively presume not to have been intended by the parties to be a legally enforceable contract unless it is in writing and B, contains a provision which, however expressed, states that the parties intend that the agreement shall be a legally enforceable contract. Now, to go back to my Lord Borough's example of the arrangement for dinner, it's acknowledged that there is it's acknowledged that obviously a question arises in terms of any forms of agreement, whether or not the parties intended to create legal relations. And that, in effect, giving rise to an obligation or set of obligations, typically a contract. And that's the distinction between, are we going to go for dinner at a particular point in time, and a commercially negotiated position. What this section does is simply reflect, as we'll see, what was found to be in a common law the accepted understanding between parties to collective agreements in the climate at the time that the parties did not intend them to create enforceable legal obligations. And Lords, that was originally derived out of, and it's a case which we all refer to, Ford Motor Company and Amalgamated Union of Engineering and Foundry Workers. That's a decision of Mr. Justice Geoffrey Lane, as he then was, and that's at 1172. Before I take you there, though, perhaps I should just make the point. It's a point we make in our case before we leave the section. The section doesn't explicitly say that the courts will not consider the terms or nature of the collective agreement, because we know that that happens. We know that it happens that collective agreements which are incorporated, as in this case, are subject to interpretation in terms of the courts. And the section itself specifically, at subparagraph 3, contemplates that if part of the agreement specifically defines that it will be legally enforceable, then whilst the remainder will be presumed not to have been intended to have had legal effect, the court can, under subparagraph 4, have reference to those non-legally enforceable parts in interpreting the legally enforceable parts. So actually, contrary to the suggestion that in some way the section's creating an area of which the courts will never have a view in terms of contracts, it actually contemplates the possibility that when looking at an enforceable part of the agreement, the court will look at other parts of the agreement, even though they're unenforceable, if they're necessary for the purposes of construction. But can I just take you to the Ford Motor Company case? As I say, that's at 117.
And in a sense, that's a more general proposition that would strike me as being a big point for you, which is that if one puts forward the idea that this is a no-go area,
yes,
which I think the other side are putting as a point, you would have to accept that there are aspects that clearly are looked at by the courts, in particular the interpretation of the collective bargain insofar as it becomes incorporated into the individual contracts of employment. So they are applying what you might call legal techniques to the construction of the collective bargain. And it's very difficult, I think, to disentangle that from rectification, because as we know, the link between interpretation of a contract and rectification is very, very close.
Yes.
You know, if the argument was, oh, well, they're only ever applying objective contextual principles of contractual interpretation to the individual contracts of employment, that would be one thing. But it seems to me, from my understanding of the authorities, that they're actually applying that to the interpretation of the collective bargain. Isn't that an important point for you?
Well, it is, and there are really two parts to it. You're absolutely right that my interpretation of their case is to say that effectively there is a cordon around collective agreements, which means that the courts do not step upon them. And they try and draw there as being a policy out of the NUM case and National Coal Board that I refer to, which I'll come to, but I maintain doesn't really support that proposition. But the difficulty with that is twofold. Firstly, that it's absolutely right, that it's quite clear that acknowledging that it's typically in the format of incorporated collective agreements that have come into contracts of employment, although it might be in other circumstances. For example, let's forget contracts of employment. It's for the purposes of trades unions, whether or not a union is recognised for collective bargaining purposes is an important issue. And to be recognised for collective bargaining persons, either by conduct or by agreement, it has to be agreed that the union will bargain on some of particular issues. And we refer in our case to issues in terms of recognition where if there are existing recognition arrangements with a union that prevents another union from seeking statutory recognition. So in that context, whether or not a union has been recognised or not frequently may involve a body, the Central Arbitration Committee, or potentially a tribunal if it's relevant to issues about, for example, whether or not there should be collective consultation, which also rests upon recognition. It's potentially necessary for a tribunal to look at the agreements and say, well, actually, has the union been recognised or not? So the answer to your first question is, it can't be a completely no-go area, because there are legal circumstances where what has been agreed between the union and the employer, if anything, has to be determined or interpreted by a court or tribunal. And the two examples would be, perhaps a better example is collective consultation, where you ask whether or not the union has been recognised for collective bargaining, and if it has been, that means you have to collectively consult with it about making redundancies. And you won't know that without deciding that primary question, and that looks at what's happening. So first question is that absolutely it happens. The second point I've already made, but I'll make it again for clarity, is that despite them saying that this is an area that the court shouldn't go to, they're directly contemplating that it should. Because we identify practical problems about an employer suing its workforce, which is effectively what they say should happen for rectification of the contracts of employment. And some of the practical problems we identify are the fact that so far as those proceedings are concerned, when it comes to disclosure, the disclosure would in principle be with the employees in the litigation, not the union. And when it comes to evidence, the primary evidence would be that of the employees who weren't parties to the particular agreement. And the unions don't say, well, no, that means that there isn't a solution. They say, oh, no, of course, the unions will be cooperative because they would have an aligned interest and therefore would give disclosure of the relevant documents. And, of course, the unions would give evidence in relation to what happened. And that reflects something that Lord Justice Underhill below said in respect of the practicalities of having rectification where the proceedings are between the employer and the unions. But that really reflects the absurdity of the union's position, because contrary to the idea that it's a policy position, they're actually contemplating only that it's a specific forum and only that it's between specific parties, but actually either the court, if it's representative proceedings against the employees, or the tribunal, if it has the power of rectification, will actually hear evidence about what happened in the negotiations, hear evidence about what the parties agreed, and decide those particular questions. So really, there are no barriers being identified here other than a fiction that you in some way should restrict the exercise only to a forum where the union is not a party. I think I was going to take you, I've got an eye on the clock, but I was going to take you briefly to the Ford Motor Amalgamated Union of Engineering case, which is at 1172. Judgment of Mr. Justice Geoffrey Lane, as he then was. And essentially what happened in that litigation was that there had been a collective agreement between Ford and the unions. And there had been an issue about the unions seeking to walk away from the collective agreement, and the company brought injunction applications against the unions seeking to enforce the terms of the collective agreement. And In the way of industrial relations injunctions, it was granted, I think, in chambers as an urgent interim application and then argued on notice. And the issue on notice was whether or not the collective agreement had been intended by the parties to create legal relations. And rather as the example that was given to me earlier, Mr. Justice Geoffrey Lane then was contrasted the distinction between the social agreement and at one level and the commercial agreement exercised at arm's distance to consider what the party's intention was. And what he does to ascertain the party's intention is that he looks at, in the context of what was the general understanding of the relationship between unions and employers in collective bargaining. He looks at a variety of pieces of, it's all at paragraphs 324 to 329, that's 11993, is the beginning of that section. And he looks in particular at evidence which had been given to the Donovan Commission in the Donovan Commission being the report of the Royal Commission on Trades Unions and Employers Associations under the chairmanship of Lord Donovan. And he looks at evidence that was given and the conclusions of that report. All of those he draws together to the conclusion that the prevailing understanding of parties was that when they were bargaining collectively, they weren't intending to create legal relations. Now, that's simply a reflection of where the parties' intentions lay. You see that being drawn together in his conclusion, which is at 1199 at section G. He looks at subjectively the party's intention and objectively looked at the context of arrangements that existed in general industrial relations. So really it was categorising it by something reflecting what the parties understood when they were collectively bargaining. Now, what happened is that after that case in 1969, and back in the early 70s, we know that there was quite a heated industrial environment, shall we say, for these purposes. And back in the 1970s, a piece of legislation was passed that effectively reversed that position. The legislation provided, and this is set out in my learned friend's skeleton argument, case, that the legislation in 1971 reversed the position and provided that collective agreements would be intended to create legal relations unless the parties expressly stated that they were in honour only. And subsequently, that had been very contentious for the purposes of the trades unions. I should say the reference to that is B833. That was Section 34 of the Industrial Relations Act 1971. And what subsequently happened is, because it had been contentious with the unions, the Labour Party committed to changing the law when it was elected. It was elected in 1974, and the legislation that's a precursor to the present legislation was Section 18.1 of the Trades Union and Labour Relations Act 1974, which gets consolidated in the section we've looked at. So what it was doing is it was reversing back the position. And in fact, it provided that prior to 1971, it couldn't change the way the law worked from the 71 Act. Prior to 1971, collective agreements were presumed to be not intended to create legal relations unless expressly stated, and from the date of the implementation of the legislation 1974. So as a piece of legislation, it wasn't directed, it would appear, at a specific policy about creating an area where the courts wouldn't go. It was directed at reversing earlier legislation which sought to change what had been the court's finding as to the conventional understanding of parties to collective bargaining. So the closest my learned friend gets to any sort of general policy is to rely on some dicta within the judgment of Mr. Justice Scott, as he then was, in the case which I've mentioned, which is the National Coal Board case, and National Coal Board of the National Union of Mine Workers, and you find that at 1558. Very briefly, another heated period of industrial relations in the coal industry. This had the background of the miners' strike of 1984 to 1985.
I'm sorry, Mr. Reid, I got the wrong reference.
I'm sorry, it should be 1558.
Thank you. Yes, it starts at the bottom of the page. Thank you.
It's another first instance decision, and I think Mr. Justice Scott had been not long on the bench by this point, so quite an interesting case to have landed upon you, because it had the background to it was the miners' strike and the formation of a breakaway union in the form of the Union of Democratic Mine Workers from the Nottinghamshire coalfields. And what had happened is that they sought recognition for collective bargaining by the National Coal Board, and the National Coal Board, under a collective agreement dating from 1946, had an agreement with the NUM. And under that agreement, there was, and I mentioned the existence of this type of structure, there was a national reference tribunal where if there were disputes with the union, it could be referred to that particular tribunal. The Coal Board's position was that the agreement was ended, and the union, the National Union of Miners' position was that they wanted to contest recognition of the Union of Democratic Workers and wanted a reference to that tribunal. The Coal Board's position was it ceased to have any impact or rights because the collective agreement has ended and it no longer has any basis. And boldly, although they were in fact granted the relief, the National Coal Board sought an injunction to restrain the NUM from seeking to refer to the tribunal. One central question, though, which they asked a declaration on, was whether or not the collective agreement was enforceable. And, of course, the obvious answer to that was, well, no, because it's clearly defined by statute not to be enforceable. The passage that my learned friend refers to, you find at 1583. And this really reflects other relief which the Coal Board was seeking. They were granted their declaration that the 1946 agreement was not enforceable because that affected the statute, but the Coal Board wanted to have determination as to whether or not it had ended by way of frustration or whether or not there might be termination provisions under it by way of notice. And it's quite clear that actually the motivations for that weren't really legal. They were, to use a small p, political, as to show why it was that they were doing what they were doing. And the court's approach was that not to grant any relief or determination about frustration or whether or not there was an implied term. Now, we say that that simply follows because that's about enforcing rights. It's not the same as rectification. But equally, one could see that as being something, if it had been rectification, that would be a practicability issue. What my learned friend draws from this is that within that section, at the end of 1583 passage little h, Mr. Justice Geoffrey Lane says, if I've held the 1946 agreement is not legally enforceable, either party has always been free at any time to decline any longer to be abide by its terms. They argue that the law will import into such an agreement a term allowing termination of reasonable notice seems to me plain nonsense. A proposition that a contract which is not legally enforceable has been brought to an end by frustration, in my judgment, is no better. The doctrine of frustration is one by means of which parties become discharged from legal obligations which they've contractually adapted themselves to. So all of that was really just an application of the principle of non-enforcement. And I'm sorry, the passage which he then relies upon is over the page at 1584 at little g, where the judge declines arguments to say that the court should exercise any power over the agreement. There's an argument to say, well, because of the context to collective agreements of the European of the membership of the United Kingdom in the European Union, or rather the EU at that point in time, that the court should exercise some powers over the agreement, and it's clear that the court's unwilling to do so. And the phrase that he latches to is at little g. They cannot, on the one hand, keep their collective agreement outside the area of legal recognition, and it might be said legal interference by the courts, and on the other hand, ask the courts to decide questions that arise under it. Well, in the context, one can see why the judge was declining to grant relief in circumstances where all he really needed to decide was the question that it wasn't enforceable. But what my learned friend seeks to elevate that to is a generic policy that in some way the courts don't deal with issues relating to collective agreements. And as I've answered to my Lord Burrows, there really are two fundamental problems with that, because clearly the courts do, in the context that I've identified about interpretation and establishment of the terms. And secondly, actually they're inviting the court to do so here, albeit in other proceedings. So we say that it doesn't really make good a proposition that there is some area that the courts won't go to. So I should briefly deal with 3 points which are made against me. Just for reference, there are 3 hypotheticals, and we say they really do reflect hypothetical positions. The first of the hypothetical is para 21 of my learned friend's case. The hypothetical is that the employer has ceased to exist, and I'm sorry, that's yes, that ceased to exist, and there's no union. I'm sorry. First hypothetical is the union has ceased to exist and there's no union to bring a claim against, and the argument is to say, well, the claim would have to be against the employees for rectification in those circumstances. Well, that may be right, but it's not this case, because the agreement is still in place, the parties are still extant, there really is no reason to take the route of litigating with non-parties to the agreement in the form of the employees. The existence of that hypothetical is not a reason to depart from the obvious position that the sensible route to litigation is for the union to be a party to it. The other hypothetical, and this is has an interesting relevance where my learned friend doesn't understand the difficulties which we identify with rectification where it's a multi-party collective agreement, is that he identifies at paragraph 23 a further hypothetical to say, well, if in fact what the parties have incorporated is an agreement between different people, that's paragraph 23 of his case, so A and B incorporate an agreement that's between C and D, so standard terms and conditions which are in place. He says, well, obviously, any rectification argument would have to involve A and B. Well, of course, A and B aren't parties to the original agreement, and therefore they can't really bring a claim in those circumstances. That hypothetical doesn't help us here because we know that Nexus is a party in existence and is a party with whom collectively bargained with the union. So the hypothetical is really irrelevant. What it does reflect, though, is one of the practical problems that one sees in relation to the idea that there should be some form of action against the employees, whether or not in a representative capacity or not. And that's, if one steps back and looks at collective bargaining more generally, it's quite common for there to be collective bargaining arrangements that span a wide number of employers and a wide number of employees. The obvious example would be local authorities, where there is collective bargaining at a national level by representatives of the employer's side and representatives of the trades union side. And the contractual bridge exists at each level locally to bring those terms into contracts of employment. Now, if I'm looking at a particular authority, that particular authority may have included those terms, but not itself being directly party to the collective bargaining. Employees who work for that local authority, of course, are not party to those collective agreements. My learned friend's proposition would seem to say that if there was an issue about rectification, one would have to have a representative action that brought representatives of all of the affected employees across the country from different local authorities, either them bringing the action or the employers bringing a claim against them in order to resolve a dispute, which quite clearly is focused upon what happened in bargaining between obvious parties. The unions represented collectively in that bargaining process and the employers' representatives. The difficulty with all of their arguments about saying, well, that's not a big problem, you could find a solution to that. Representative action. You could have evidence given. That's not a problem. There's not really an issue about the risk of having disparate decisions from employment tribunals because tribunals will follow one another. All of those have the central problem that they're trying to avoid the obvious answer. Why do we need to do that if we can have a straightforward solution, which is that the union is a party to our rectification? So we say, it's blindingly obvious when one realises that if there isn't an obstacle, rectification shouldn't be barred when it comes to the collective agreement with the union. I acknowledge points about the exercise of that discretion. There may be issues about the effect of rectification, prospective, retrospective, but so far as the appeal is concerned, those are arguments for another occasion. The primary issue in relation to the appeal concerns the question of whether or not there's an area that the courts shouldn't go, and we say that's not either as a point of principle in rectification or as a point of principle in collective labour law. I've 3, 4 and 5 I'm going to deal with. I've got an eye on the clock, so I'll deal with, you'll appreciate that from our perspective, the primary issue is issue ground 1.
Mr. Reid, if it assists, you can eat into your reply time.
Yes. Can I ask for a point of guidance? Because I think when we planned time in relation to this, we understood that the court rose at 4. When we had the listing, we were told it was 4:30. My understanding is that you normally rose at 4.
We're rising at 4.
But I'm grateful then that the listing information we had was wrong and we were right in our assumption on timetabling. I'm happy to eat into my reply to a limited extent. I don't want to spend too long on the issues. There's one of the issues, issue 3 and rectification before the employment tribunal is one of perhaps wider significance. Obviously, so far as the appeal is concerned, it has particular purpose from the point of view of Lord Justice Underhill's reasoning that there was a cause of action and issue estoppel. For those purposes, it has to have been possible for the employment tribunal to have determined issues of rectification. The arguments in relation to abuse of process don't seem entirely to rest upon that. The arguments about abusive process also appear to rest upon the question of rectification not having alerted, raised as an issue before the Employment Tribunal dealt with questions of construction. On rectification before the Employment Tribunal, there's no issue that the conventional understanding before the Court of Appeal judgment in this case was that tribunals didn't have a power of rectification or wouldn't embark upon questions of rectification. And we refer, and indeed does the respondent, to the case of Mango, Hare and Dos Santos. I don't perhaps need to take you to it other than reflecting the EAT proceeding on the basis of that being the accepted understanding.
There's a difference, though, isn't there, between having the power to order rectification and being able to decide whether an agreement should be rectified.
That's true.
Because there's a line of authority that you don't have to order rectification. You can treat the agreement as if it had been rectified for the purpose of deciding an issue. And there's a Court of Appeal referred to a couple of old cases, Mostyn and West Mostyn.
Yes.
But neither party seems to have drawn our attention to the fact that in Hodge, those cases seem to be just the tip of an iceberg, and there's a whole line of authority that takes that approach.
Yes, although what I observe in terms of that approach is, and I think those are authorities which the Court of Appeal directed the parties' attention to, and they're referred to in the footnotes to those particular cases, in the footnote to Snell on the particular passage, and Lord Justice Underhill relied upon them. It's notable that the other two members of the Court of Appeal didn't rely upon those authorities.
Yeah, but that's the cases under the Judicature Acts, which might seem a bit unusual, but there's a whole range of subsequent cases in Chapter 1 of Hodge, such as one called the Nile Rhapsody in 1994, where the Court of Appeal has on about 5 or 6 occasions taken the view that you can treat a contract as if it had been rectified without having to order rectification.
Yes.
On the basis that equity treats as done what ought to be done.
Well, can I just deal with that in two ways? Firstly, all of those cases, I anticipate, without reference to the authorities, would all be cases decided within the civil courts. And although the root of those cases is identified by Lord Justice Underhill, are old cases which concerned in particular the Judicature Act. What's clear is that the subsequent legislation, successor legislation defining the jurisdiction of the High Court, meant that although the Chancery Division itself would exercise the power of rectification, it's clear that other divisions of the High Court or the civil courts would deal with questions of rectification by way of defence, and I don't take issue with that. What I say, though, is that my learned friends confuse a question of jurisdiction with a question of legal powers, in the sense that when it comes to the Employment Tribunal, one can't say, and I take your point, that there's a distinction between determination of a defence and exercise of rectification. One can't say that there's any form of power at all in the Employment Tribunal that gives it a power of rectification. The only power that one can identify is the determination of sums which are properly due.
Fine, but if in order to decide whether a sum's properly due, you have to decide whether the contract should be taken as read or whether it should be treated as if it had said something else, because it ought to be and is capable of being rectified, then you can decide that on the way without having to exercise any power to rectify.
Well, the difficulty with that, apart from my argument that it's rooted in the wider jurisdiction of the civil court, is that where does that one leave one in terms of that process? One's decided it only inter partes between the two. One hasn't changed the underlying agreement in relation to matters. That the absence of that power, it means that it's a sterile exercise.
You've effectively declared the meaning of that agreement, and that will then be persuasive for other tribunals and potentially, depending on appeals, a final decision about the interpretation of the agreement. Just as you said, there can be an interpretation of the collective agreement on an application for a declaration by the union, let's say, why can't the tribunal, just as it did in Delaney and Staples, proceed on the basis that general principles of law are applicable when determining what is properly payable under Section 13, subsection 3 of the 1996 Act?
Well, firstly, I don't question general principles of law in terms of principles of normal contractual application. So my learned friends refer to illegality, penalty clauses. I acknowledge...
This is interpretation, isn't it? This is just...
Well, acknowledging that no doubt Lord Burrows will go back to his observation that the distinction between interpretation and rectification is a narrow one, I respectfully suggest that actually it's quite distinct in this context, because if one's determining what's properly due in relation to a particular contract, one's interpreting the material before you. What's contemplated with rectification is one's not determining the interpretation of the material before one's hearing material and evidence to say that what appears to be the documentation before you does not accurately reflect the agreement of the parties.
But leave aside the collective agreement element of this, which obviously introduces another factor, how that interacts with the individual contract. Just suppose a single contract of employment, and it's argued that the terms of the contract don't actually represent what was agreed, and then there's a claim for wages. Are you saying that if the Employment Tribunal can't decide what the contract was meant to say, and if you want to argue that point, you've got to go off to the High Court?
Well, if the documentation is if one's dealing with a case where it's a dispute about whether or not there was an oral agreement or not, obviously the tribunal has to determine what the agreement was between the parties. But if one's looking at a case where the documentation is on its face, the documentation which has to be interpreted, my position is that you'd have to go off to the courts, as happened in Mango, where the AT's approach was that...
Why? Yeah. Why? I don't understand that.
Because one's looking at a wider jurisdiction that might be contemplated for the statutory tribunal.
Well, you're determining what is properly payable under the contract, and if the contract is not reflective of what the parties intended by virtue of a common mistake or a unilateral mistake, why can't the tribunal determine that?
Well, I'm going to answer only by holding to my argument that within terms of the jurisdiction of the tribunal, that extends well beyond the interpretation of what is properly due. I accept that is clear from Delaney and Staples, that's something which the tribunal is charged with doing, but I say rectification takes that a step beyond, and if Parliament had intended it to have a power that effectively enabled it, although it's not ordering rectification, it's in effect achieving that result. If Parliament had intended it to have a power by way of rectification, which is granted to the courts and is used in other divisions beyond the Chancery Division in defence, it would have given that power, and it didn't. Can I very briefly deal with the other the other 2 points. On abuse, I've probably exhausted all that I can usefully say about the approach in relation to that. Obviously, the approach of the Court of Appeal was twofold. Lord Justice Underhill had a approach where there was issue estoppel and cause of action estoppel. That really only runs if you're against me on rectification being open to the tribunal, because it required that to have been something that the tribunal could have determined between the parties, subject to issues about whether or not the unions are entitled to rely on being privy to that particular judgment.
It doesn't really add anything. I mean, it's just a harder argument to make than the abuse argument, the cause of action or issue estoppel.
Yes.
Or if it adds anything.
No.
I mean, there's no need, if there's an abusive process, it would be an abuse to argue it, then there's no need to consider cause of action estoppel, an issue estoppel, and if there isn't, well, they're not going to succeed on, I don't think, on cause of action or issue estoppel.
Well, no, I acknowledge that the effect of either is the same, yeah. And the bigger target for me is obviously the abuse process, and obviously,
it's also potentially wider than because on any view, cause of action, issue, estoppel are limited to the parties and their privies and not to other.
Yes, and that's why I acknowledge that issue 5 and privies only really runs in relation to parties, because estoppel's only directly, whereas I accept that abuse as a principle is wider in terms of the discretion of the court and isn't limited in the same way.
And it would also apply in a case where the party had failed to alert the court or tribunal to a possible argument, the oldie case. Yes,
well, obviously you'll appreciate from my case that what I rely on in relation to that, and I acknowledge it was a decision in which there had been no argument about abuse, was the Crane and Hegeman and Harris case, where there had been an issue that went to arbitration, and the arbitrator had no power of rectification because their power as an arbitrator was under the contract itself. Having lost at arbitration, a party then brought rectification, and there was an attempt to argue that there was an issue estoppel. Now, I acknowledge that abuse wasn't run in relation to that case, and I also accept that as a decision it was from 1939 and that we have seen movement in the law since 1939. My point from it is that the idea that parties may have had an expectation that everything was settled and certain in relation to matters doesn't really establish that it can be seen as being inconsistent with that case, because the parties to the arbitration may have said, well, as far as we're concerned, this is finally resolved matters, only to then find that rectification was being prayed in aid against them. And what we say the Court of Appeal did in the majority judgment, in all 3 judgments, was really elevate to an idea of principle that there ought to be some expectation of the workers that they had the Anderson claimants in particular, that their position had been resolved by that litigation, and that they shouldn't face the issue being reopened at a later point in time. Well, that, we say, supplants the broad merits test that has to be applied, and really my best point is that the Court of Appeal shouldn't have embarked upon that at that particular stage. The Court of Appeal should have left that question to consider when that merits exercise would have been balanced, if either it had been in the remedy proceedings before the Employment Tribunal in the Anderson litigation, or in rectification proceedings, if, to take my Lord Sale's point, there had been an issue either by way of abuse of the process or as to the limits of rectification, whether or not there should be some limitation as to the scope of rectification itself. So we say they were wrong to adopt that approach, then it should have been left. The privity issue at 5, and I take the practical point I note, that actually that really only has a relevance to issue estoppel and cause of action estoppel. Only Lord Justice Underhill formed a view in relation to that. There's no issue between us as to the principles of law. They're very clearly set out in Resolution Chemicals, and what's necessary to show if one's not a party in the original litigation, but it's said that you are someone who is privy to the parties in the original litigation, is that you need to examine the extent to which the new party had an interest in the subject matter of the previous litigation. This is at paragraph 32 of Resolution Chemicals. B, the extent to which...
do you have the page number for that? Just so we can...
I'm sorry?
Do you have the page number?
I do apologise. It's page 1668.
Thank you.
Paragraph B within Resolution Chemicals.
Paragraph
32.
Thank you. B, the extent to which the new party can be said in reality to be a party to the original proceedings by reason of the relationship with that party. And C, against this background, to ask whether it's just that the new party should be bound by the outcome of the previous litigation. So when principle one has someone who wasn't a party in the original litigation, but those factors mean that it's right to dictate that they're bound by it. And Lord Justice Underhill found that the unions were such a privy, and we say he was wrong to do so, because the unions in fact had no
direct interest in the original litigation. Yes, they were members of RMT. Yes, it may have supported the Anderson claimants in bringing their litigation for unlawful deduction, but it had no financial interest in the outcome. Its interest, at best, would be as a union in the success of its members in bringing that particular claim. And the type of interest which appears to be contemplated is something more direct or financial, so a patent which is determined, which impacts upon the interests of another party in commercial terms. And perhaps more critically, if you look at the second test, the extent to which the new party can be said to be in reality a party to the original proceedings, well, that doesn't begin to run, because as I've identified, the union, if it wanted to seek a declaration as to the meaning of the collective agreement, we say could have started its own proceedings, but it could never have been a party of the employment tribunal. It simply couldn't have been a party in that litigation, or that the only party they could have ever been would have been the employees. So in no sense was it ever a party, and the judge was wrong to conclude that they met the test in Resolution Chemicals to be a privy to that litigation. I wonder if I might, I think I've dealt with the matters I want to deal with an eye on the clock. I wonder if I might have a moment just to check with my learned friend if I'd missed anything, and also I can see that I've had some messages which I haven't read. Excuse me a moment.
Of course.
Maybe too late.
This has replaced the yellow post-it note, has it?
This is replacing the yellow post-it note, and I have to say I prefer the yellow post-it note, but maybe old school. Worse still is doing hearings with WhatsApp, where things constantly pop up.
At least you haven't got the tag on the back of the gown.
I'm grateful. I'm told that I've dealt with it, so even better. I'm very grateful. I acknowledge that I've used 10 minutes of my reply time.
You've got 20 minutes left for the reply. Thank you, Mr. Reid. We're grateful. Mr. Siegel.
Lady and Lords, good afternoon. Ground one, we say it's important, as, to be fair, the members of this court have done, to subject the contention of Nexus, the provisions of a collective agreement can be rectified, to some quite careful analysis. What provisions and in what circumstances? Because we say that once analysed in that way, the contention becomes untenable. It's commonplace, and it's been discussed between bar and bench this morning, for collective agreements to contain both provisions which are not incorporated into contracts of employment and provisions which are. And I focus first on those provisions which are not, those, for instance, that govern collective dispute resolution. Let's say that some months after the collective agreement is made, the employer and union dispute whether what had been agreed between them was accurately recorded, and it may be of considerable, and I choose this word carefully in light of my learned friend's submission, practical importance to establish, say, whether the collective parties had agreed to binding arbitration at ACAS. Practical in the sense of hugely practically important to the workforce, the employer, the industrial relations between them. Now, I had proposed to say before this morning that it is entirely uncontroversial that neither party could invoke the jurisdiction of the courts to resolve such a dispute. The reason being that the provisions are not legally enforceable. And that's the ratio of part of the NCB and NUM case, which I'll go back to. It now turns out not to be uncontroversial, and I begin to see why, because in a sense, my learned friend's submission orally, and apologies if I hadn't apprehended it from the written case, is much wider than that rectification might apply to terms of contracts of employment deriving from collective agreement, The case now, and if it always was, again, I'm sorry, is that any document which has practical importance made between more than one person is one that the courts, subject to other equitable constraints, may rectify. And that, we say, is completely heterodox, not just in the context of collective agreements, but generally. And I will come back to the passage my learned friend took you to from Chitty, and indeed to the cases that Chitty cites in support of the proposition there stated. So I move now from terms of collective agreements which were never meant to be, and no one is arguing could be legally enforceable, to a more interesting category perhaps in the context of my friend's submissions. There is very often a dispute between employer and employees as to whether a provision of a collective agreement is an enforceable term of the contract of employment. And there are many cases in which such disputes have been resolved. And they have always been resolved between the parties to the contracts of employment. Many of those cases are reported. Many of them have gone up to the Court of Appeal.
I think there are two questions that need to be distinguished in the argument. One is, can you rectify a collective agreement, and if so, which terms? And the second, different question is, between what parties should that question be resolved?
My Lord, absolutely. But we say, and I accept this has not come out this morning in the discussion between my learned friend and the court, but we say that those two questions are much more intimately related and interdependent than my learned friend would have it.
Well, at the moment, I can't see how rectifying the contract of employment would do any good to anyone, because it just says that we incorporate the terms of the collective agreement. And in order to affect what's changing what the contract of employment means, you've got to rectify the collective agreement. Now, whether that has to be done between the employer and the union, or whether it can be done in proceedings between the employer and employee, is a different question.
Well, my Lord, we respectfully say the exact opposite. My Lord said, in envisaging the term of the contract that might be rectified, that the incorporation term might be an issue. That is to say, the term that says any collective agreement made between Union X and the employer that deals with, I'm making this up as I go along, matters of pay will automatically be incorporated into the contract of employment. That isn't the relevant term. The relevant term is, we will pay you overtime at the rate of X based on your base salary of Y. And from the moment that that letter agreement was, I use the term loosely, ratified, because you'll recall what happened was there was a collective negotiation and then a vote of the members to decide whether or not they accepted it. But from the moment at which the metaphorical handshake took place, the vote having endorsed it, that became a term of the contract of employment. If it hadn't, we wouldn't have had Anderson, we wouldn't have had any suggestion of rectification. And what is being rectified, if it's to have any utility at all, is that contractual term.
Which term?
The term as to the entitlements of employees grades 1 to 3 to pay, and in particular in relation to overtime. Put it another way, if you were only rectifying the collective agreement and not that term of the employment, what good would that do anybody? Would you have another vote of the new text as rectified so that the employees could consider whether they want to accept that, or are they bound by...
Well, it would help me at some point at least just to see what the terms are that the term is that you say is a term of the contract of employment that's being sued on.
Well, I mean, it is the letter agreement. One takes
Yeah.
it from the statements of facts and issues. Probably
That's the agreement between the union and the employer.
Yeah.
So where is it in the contract of employment that term appears, or does the contract of employment say the Red Book is incorporated?
Yes, it's the latter. I mean, when
Exactly.
if my lady says appears, as in physically
Yes.
appears, as my
doesn't.
lady knows, the contract of employment of any employee and employer where there is recognition will not constantly be rewritten.
No, well, what I don't see is how you can alter the rights and obligations as between the employer and the employee in their contract of employment on the assumption that the employer's right about what it was intended to say in the Red Book without rectifying the Red Book.
Well, it's my obtuseness, but I don't understand why one needs to rectify the Red Book as per se.
Well, as between the employer and employee, surely their intention was that the obligations and rights as between them will be whatever it says in the Red Book.
Well, there are, I suppose, two interpretations of what the employer and employee thought. One would be that whatever the text of the Red Book is, that is the term of the contract of employment. The second would be whatever the collective parties intended to agree would be the term, and that is obviously the premise on which the rectification application is made, and I accept it.
I'm not sure it is. The premise, I thought, was the first of those, and that therefore that's why they want to rectify the collective agreement, and that will then, when the text of that is rectified, it will feed through automatically into the employment contract.
Well, perhaps we're at crossroads. My Lord, I'm not saying that if you could rectify the collective agreement, that it wouldn't feed through into the employment contract.
So are you saying the intention to be attributed to the parties to the employment contract is to incorporate not whatever the text is in the Red Book, but whatever the parties to the collective agreement intended the text to be?
Well, what I'm saying is whether it's a question of interpretation, whether it's a question of whether it's a term at all, i.e. the apt for incorporation or not apt for incorporation question, or whether it's a question of what the correct record of the term is, all those three are questions as between employer and employee, albeit that in this case they would all relate to a provision of a collective agreement.
Well, at the moment, though, the way I see it is that unless you can alter the text of the collective agreement, you're not going to affect the rights and obligations between the employer and the employee, because I don't think they intended to do anything other than incorporate what was said in the Red Book.
But, my Lord, again, I'm not sure there's as much between us as I'd thought. If there's an action, as everybody expected there to be, and as Nexus originally said there would be, an action to rectify the contractual term as between employer and employees. That's what they said they were going to do until we said, hold on, you might be stopped. And then they switched tack. And it's also what they're arguing, albeit they say that the tribunal doesn't have jurisdiction to accept their argument, by way of defence against the employees' claims in relation to the tribunal proceedings post-Anderson. So it's not really that anybody has said that you can't rectify the term of employment. I accept.
Well, I'm suggesting that to you, whether they've said it or not. And I'm suggesting that what they'd have to do is to rectify or to treat as rectified in the proceedings, the collective agreement term.
But, my Lord, that would be the effect of a finding in favour of the employer in relation to a claim that the term of the contract of employment as deriving from the collective agreement needs to be rectified. That would be the effect of the success of such a claim. So I accept that if the claim had proceeded as originally proposed by Nexus, between Nexus and its employees, saying you, the employees, are relying on a term of your contract which has been misrecorded and it needs to be correctly recorded, I accept that if they had succeeded in that claim, and they may still pursue it, they say, and they may still succeed in it, the effect of that is that the court is saying that the letter agreement has been mistakenly recorded, which of course means that for all employees whose contracts incorporate letter agreement, their terms of employment are pro tanto rectified. But it's very important, we say, to observe the overarching legal principles applying both to rectification and to collective agreements versus contracts of employment, and do it that way round, rather than say, on the facts of this case, and as we're about to find out, there are facts of other cases where what my learned friend proposes would just be wholly impossible, not just inconvenient. But on the facts of this case, it would be more convenient, now at least, they say, to bring that claim by way of an action against the unions in order to achieve the same result. We say that is heterodox by reason of the principles attaching both to the remedy of rectification and the justiciability of collective agreements. But the result is the same. It's not that we're seeking to deprive them of the result or of any content of the result. It's
well, I can't see what's so heterodox then. It is just a matter of procedure.
Well,
I mean, could I put it this way? Why couldn't your argument accept rectification is possible at both stages? You could have the rectification as between the individual employees and the employer, but you can also, and often it on the face of it would seem very convenient, to have rectification of the collective bargain.
Well, my lord, if one were creating a common law system from scratch, I can quite see that that might be an appropriate way to proceed. But my arguments are based on the legal principles established over at least half a century and more in relation to those two principles. As I say, the applicability of rectification and its limits, and it does have limits, and the justiciability of collective agreements. If it weren't for those two legal principles, and this case arose and we were to decide what to do with it.
Well, there isn't any authority for your proposition, as far as I can see, except for a dictum of Mr. Justice Scott.
Well, all right, can I...
The Court of Appeal didn't give any reasons for their assertion that you can't rectify collective agreement. They just said you can't rectify an agreement unless it's one that is legally enforceable.
Well, Mr. Justice Scott doesn't deal, of course, with rectification.
No, he doesn't. No, it's why but it's a sort of it's some suggestion that you can't trespass into this area at all if you're the...
Well, I would say it's more than some suggestion. Yeah. It's a fully reasoned judgment in complete accordance with what had been said, and indeed, as Justice Jeffrey Laney was then, records in a painstaking review of the history of this for many decades previously. But that's the second principle, the non-justiciability principle. Can I start, though, with the first? And albeit one very rarely spends too long analysing the same two lines of print, can I invite you back to 1904? Because I do say that it neatly encapsulates one of the principal fallacies of my learned friend's argument. that is a passage in Chitty. We'll go to the citations, but rectification will only be ordered so long as there is an issue between the parties, that's to say the parties to the action, as to their legal rights inter se. Now, a pausing there, if that was the only sentence, it would be, I would say, fairly robust support.
Well, if that was correct, then you, if that is correct, then you're right.
I am, I would say.
There's no little number after that sentence.
Well, my lord, there are citations, and I'll take the court to them in a moment. But can I first deal with the next sentence?
Do those legal rights have to be direct legal rights? Because it could be said against you that this collective agreement creates indirect legal rights inter se.
Well, not between the union and the employer. It would be between the employer and somebody else.
Yes.
Well, that's right. Then they wouldn't be inter se.
Okay.
And can I? Sorry, I don't wish to be overly pedantic, but can we just read the next sentence? Because my learned friend took the next sentence as, in some sense, qualifying or contradicting.
Well, no, it doesn't qualify the first one.
No. Well, there's a key word in the second sentence, and that key word is all, as opposed to and.
Yeah.
So what the second sentence says, as you've all already appreciated, I can see, is that if there is no such issue, miss out the middle words, rectification will be refused, or if no such...
Chitty's putting these as cumulative requirements, not alternative requirements.
I knew my lord would have the point more quickly than I. But so then let's look at the cases. And the first is Whiteside and Whiteside. I'll turn to it in a moment, but just the facts. Mr. Whiteside was separating from his wife and executed a deed in favour of his former wife. Everything went fine. He was to pay her basically £1,000 net. And then after a couple of years, the tax authorities said, well, hold on a minute, we think you've got it wrong. In respect to future years, you're going to have to pay more tax than you thought. And they immediately executed another deed, he executed another deed, which put matters right going forward. So matters had gone okay, and now they were going to go okay. However, for reasons that aren't entirely clear to me, a claim was brought to rectify the original deed. If we go to page 1827, within the judgment of Lord Evershed, Master of the Rolls.
And who brought the claimant against whom?
It was the husband, Mr. the ex-husband, against the ex-wife, Mrs. Whiteside.
Thank you.
The legal right having been established by the deed being one of he being under an obligation to pay her a sum of money. So it wasn't a contract, but she had a legal right under it, as with any deed or covenant of the sort. And so Lord Evershed gives the leading judgments, and 6 lines from the bottom of the page said this: the fact of their having been that rectification inter partes, in other words, the supplemental deed, is to my mind the vital element in this case. And then next page, 6 lines down, he cites an earlier judgment of his in the Van der Linde case, where he had said, where on the facts it is shown that there was never any obstacle as between the two parties to the deed to put right any mistake, it would not be a case in which on any view the court should exercise its discretion. Then at page 1831, 4 lines into the paragraph in the second half of the page, so the paragraph begins the only real matter of substance, 4 lines down. The ground, however, upon which I prefer to base my conclusion is that which I've already indicated, that having regard to the rectification deed which followed and was a consequence of the absence of any issue at the time between the parties as to their true rights inter se, the necessary condition for the exercise of the reforming powers of the court is really absent. And then in the same vein, next page, 4 lines down, Now, that seems to me to postulate that in a case in which this equitable relief is sought, that one party must be asserting a right against the other and calling on the Court of Equity to say that it is inequitable and unconscionable for the other party to stand upon the terms of the instrument as executed. That condition is wholly absent. There's never been an issue between the parties. And then if I skip 4 lines, it follows that as between the parties, no issue remains, no substantial matter, which can form the basis of the claim in this court. 1833, Lord Justice Cohen, beginning of his judgment, excuse me, by 2 of the opinion this appeal fails, I very much doubt whether at any time the plaintiff had a cause of action against his ex-wife, the first defendant, in respect to the matters alleged in the pleadings, skipping some 8 lines. When the matter came before the judge on March the 11th, there was no issue between the parties that the judge could determine. I cannot think that in those circumstances it would have been right for the judge to grant the discretionary remedy of rectification. Now, I take that decision because it's the one that is then cited in a whole line of further cases, one of which, Ashmore, we've cited in our case. Page 1654.
Well,
sorry, I've just looked at the clock.
Yeah, I think it's probably time that we take a break now, so we'll resume at 2 o'clock. Thank you, Mr. Seaman.